rise for the public hearing. Pledge, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the public session of the August 26th. We've got a public hearing that's coming up for establishing a moratorium for buildings exceeding a certain height. We have a public comment section before that. You have 3 minutes in the public comment section. Would anybody, we have a lot of people who've signed up here, but I have a strong feeling a lot of people who've signed up here want to speak in reference to the public hearing. So if I call your name and you want to speak to the public hearing, it's nothing else. You say defer to the public hearing, then I'll go back to this order here, okay? Neil Smith. Mitchell Jacobson. Evelyn Conrad. You want to speak or you public hearing? Okay, all right. John Bennett.
They'll open up and ask if you need to speak.
Yeah, I'd like to speak.
Okay.
I think I need to speak. It's important.
He'll give
Yeah.
you that opportunity.
So, yeah, I'll call your name when, yes. Steve Angel.
Defer to the hearing.
Diane Bruce Grossman.
That's by letter. To be
Oh,
read in the
okay,
public.
all right, by letters, right. Mark Fish by letter.
Same.
Adam Tallman by letter. Calvin.
Defer.
Defer. Melvin Heller.
Defer.
Defer. Rob.
You've already defer.
Okay. And Tom Dean.
Defer.
Jay Bialaski. Yes. Defer. Okay. Mackie Finnerty. Lucy Howard. Philip Howard. Alexander Howard. Lisa McGowan. Defer. Jay Deasing. Anyone who would like to make public comment that didn't sign up here? Okay. Do you want to speak in the public hearing, or do you want to speak in the public?
I don't know what
You want to speak in the public hearing?
I like to talk about home.
You want to speak? You want to speak? I'll tell you when to talk. Okay. All right. Okay.
You know my issue. Good.
Okay. All right. So since there's no public comment, we're going to close the public comment section. We're going to go to the public hearing. Rick,
Want me to give a brief overview of the...
Let me make a motion to open the public hearing on this. So, to make a motion, open the public hearing on local law, establish a moratorium with respect to issuance of building permits and other approvals for one-family dwellings which exceed certain height limitations. I'll make that motion. So, a second?
Second.
Any discussion? All those in favor?
Aye.
Okay, Rick, we're going to summarize this.
I'll give a brief summary of it. Of course, the local law is in front of you and been available to the public, so I'm not going to mention every detail in it. Basically, if the local law is enacted, it would prohibit issuance of a building permit, architectural review approval, certificate of appropriateness, etc., for construction, reconstruction, alteration, or enlargement of a one-family dwelling if the proposal exceeds the maximum height limitation set forth in the moratorium local law. So during the period of the moratorium, the maximum height limitation would be 35 feet measured from the average elevation of the natural grade along the front of the dwelling, except that if the roof pitch is flatter than the pitch set forth in the local law, then the maximum height would be 27 feet, measured the same way. There are also provisions in the local law for an application to the Board of Trustees by an individual property owner for an exemption from the moratorium. And the period of the moratorium is 6 months from its effective date.
Okay, and this board will not be taking, we will not close this hearing tonight. We will not be taking action on this tonight. And the reasons for that, Rick, would you explain, please?
Okay, primarily, other than the fact that we may have a lot of public comment that we want to consider, we cannot act on this local law until we've heard from the Suffolk County Planning Commission. There is a requirement in the law for referral of certain types of proposed local laws to the Suffolk County Planning Commission, and this falls within that category. We have not yet heard from the Suffolk County Planning Commission, so we cannot act tonight, and we cannot act until we do hear from them or a much longer period of time goes by.
Thanks, Rick. Also, this is a public hearing in reference to this moratorium about building heights. We're not going to address active applications or proposed applications in front of any board. So I'm going to ask that you keep your comments to only this moratorium, and so that way this public hearing can actually be a very constructive and productive process here. I've also invited the building inspector to come and speak to the board tonight in reference to kind of how we historically have measured building heights and the starting points. So, and the impact that FEMA has had on building heights in the village of Southampton and throughout the entire area. So, Mr. Foster.
Good evening, everybody. Oh my God, thanks. All right. I have an example of a property that has been in the news for dealing with FEMA. Can I use that with your permission, or just use the elevation?
Is it an active application in front of the one of the boards?
Yes.
I'd prefer not to do that, so
Okay. Because
unless the board wants him to do that. So,
I outlined
Okay.
elevations
Okay.
just to show how FEMA works.
well, since it probably would be a good example to, I don't know, Rick, do you think we should use an active application in front of a board as an example of how FEMA works or not?
I think it would be better not to refer
Okay.
to a specific application. If
Okay.
you want to allude to specific facts or
Okay.
elevations or whatever that might be involved in a particular application, just as an example, without referring to the application, I don't have a problem with that.
I think I can do that.
Okay.
If we knew what the application was, I might be able to consent to that.
I think we'll just keep everybody guessing, John. How's that? So,
Okay. You want one of each, sir?
You want to pass that to them?
Yeah.
Freezing in here.
Yep.
Do you have this one? No, you have this one. Do you need,
Pardon?
do you need?
This is for take one, pass it back.
Okay, if I could start. For the board, dealing with FEMA is not just a name, it's stands for the federal agency dealing with the federal flood program. The first sheet I gave you was about mandatory purchase flood insurance. For anybody to get flood insurance, national flood insurance, federal flood insurance, they have to go with a program sponsored by FEMA. And that's, the village has adopted that. The insurance doesn't seem like that much. It's $250,000 to $300,000, and when we have homes that are 10 million, 20 million on the ocean, it doesn't seem like much, but I don't think we want to say here we're going to discontinue the program and not give these insurance discounts to local residents. What we also do, as other communities, when we have the way it's set up is FEMA will say there's a base flood elevation. The base flood elevation is dealing with the structure itself, so when wave action comes in, it's not going to keep hitting the structure and shaking apart, where then it starts falling apart and all pieces gets washed onto the neighbor, maybe knocks his house out also. So we're always looking at flood insurance elevations, and we go plus 2 feet on an insurance base flood elevation. Plus 2 feet gives the village and its residents for flood insurance a cheaper rate of insurance. So that's one of the cost-saving things this policy does and what we're doing here. I can just show you. This is a basic flood insurance rate map. It shows the property, where it's located, gives elevations that are required. This was approved by FEMA in 2009. The property I'm looking at as just an example here is in the flood zone elevation 16. That's based on the new FEMA map we have here. The old FEMA map, much easier to read. You could see the properties, the house would be drawn on it. The new maps are more confusing and harder to read. This is the old map, which was 1987. Okay, and the same property in 1987, which affected other houses that were built before 2009, was at elevation 9, AE 9. So that's what, 7 feet, 8 feet higher than the new, or lower than the new map. So the new map and FEMA requirements for the flood insurance rates, because of storm surges and problems we have like Hurricane Sandy and maybe future looking worse, that's why FEMA has raised these base flood elevations. So when somebody comes in front of the village and they want to build a house in a flood zone, the velocity zone is the worst one, and that's where this house is. If you look at this map I gave you here, it gives a section through the house. People get confused with elevation versus height. The National Geodetic Service, they have permanent monuments throughout the village, throughout the whole country, where surveyors reference points of elevation dealing with sea level. So when you're talking that, if we say, in this case, the road elevation in front of this house is 7.6 feet, that's from sea level. On this property, sea level is 0. The maximum allowed ridge of the house would be at 53 feet. Okay. The actual allowed footage in the village is 35 feet. So where we're taking the base flood elevation, just got to bear with me here, base flood elevation is elevation 16. That's from sea level, 0 to 16. So 2 feet above that would be where the freeboard would be. In other words, a freeboard, if the piles are here, you want to have the structure clear for 16 plus 2 feet to 18. So the wave action, if it scours the bottom of the house, anything in the garage, that's going to be what's going to get hurt. And hopefully the piles are sturdy enough to keep the house from shaking and falling apart. So with that, the actual height of the house is taken from elevation 18, where the freeboard is, and it can go up to, based on our code, 35 feet. Now, with the moratorium, that may be one thing that you want to consider. If the freeboard brings the house up, does the whole house go up, or does the freeboard bring the first floor up and then the roof stays down here? And when you're doing that and dealing with that, you also have to consider, what are these houses going to look like with flat roof designs, other than you have some modern contemporary that work very well with flat roof. But the village has always been known for great roofs with high slopes to it, high pitches, and you have some of that on the beach, and you possibly could lose that if you're going to lower the roof heights, the ridge heights. So again, from sea level, this is 53 feet to the ridge. The top first floor is going to be at 18, so probably the average grade they're saying here is about 17 or 18. So that's where the fill is brought in. If you're familiar with a lot of the properties in West Hampton Beach, they have the houses up on the piles. They have lattice work crossed in front because they're not allowed to bring fill in, and you have a 90-foot stair to get to your front door every time. It's like a New York City apartment, I guess. Do you deal with the stairs all the time? The village has chosen to go ahead and allow mature landscaping, fill, to develop the properties, and good for the village. It also develops a tax rate because these houses are worth a lot more. Taxes go up, and that helps the whole district and all the village properties and the citizens that live here. Also, I would think the amount of fill, which is compatible sand that goes with existing dunes and then replanted, that it's also something that would slow down wave surges and maybe limit their action or reaction at an adverse effect to the village. So that's the basis of what we've done over the years, dealing with the base flood elevation, raising the house up to meet structural safety, not to have the house jeopardize a neighbor's house. So, and that's
So, let me ask you a question. So this is sea level, okay? So
Yes.
on the example that you showed us here, the average crown of the street was 7 feet, 7.6
Yeah.
feet.
right. So 7.6 below the street that exists today, the top of pavement, that's sea level.
So, let's take Halsey Neck, for example. And Halsey Neck is, part of Halsey Neck is in this zone, and part of the Halsey Neck is in the 14 zone, the 13, the 12, the 11, all that. And they're going from sea level up to that point, right?
Yes, if it says elevation 14, yes.
Okay. All right, so,
In an AE zone, which is less restrictive because there'd be less damage based on location, the elevation is based on the top of the floor, not the substructure underneath. So they figure that there'll be less wave action, and you can build it down a little lower.
okay.
So, all right.
I'm just trying to get my hands around.
Yeah.
How many homes in the village are actually negatively impacted by the moratorium, change in heights? And, I mean, just, I personally don't think there are a lot, but, I don't know, what's your opinion on that?
Well, dealing with the actual code for working with FEMA, of course, we have many properties we deal with. You can take some of them around the lakes and the creeks. They're not right on the creek. They may be off Halsey Neck Lane, as one house is.
Right.
And so you have to raise it up also some to get it out of the wet zone, the structural zone.
Yeah.
So,
Okay.
so there's quite a few properties.
Quite a few properties. Okay.
And also, what we also do is, if there's flooding of the neighbor because of the fill brought in, we'll stop them, and we'll go over where we would like to see drainage to take maybe roof runoff, or drainage to take just regular, where they have the sod or the grass. We don't want it pitched where the neighbor that's now lower, because they were under the old FEMA law, and this one's going to be up here. We don't want them to be flooded. So sometimes it takes a retaining wall, which we want the retaining walls to be addressed by having landscape in front of them to buffer the neighbors, so they don't have to look at that.
Okay.
Why does West Hampton not allow fill?
Well, it's just always been, I think Sagaponic, from what I understand, is also saying they don't want to fill.
Because I know years ago there was a lot of talk about breakaway construction, which has always intrigued me, and I could never figure out why we're not on pilings,
No.
but we are on pilings, but you can't see it, which always made me wonder, does the breakaway construction work
Yes, it does.
even
Well,
with the fill?
With our designs also, on pilings and with the fill, you can put a concrete block, solid concrete block wall that is designed where it's not connected to the piers or the columns, so if it's going to get hit, it'll, under the pressure, wave pressure, it'll collapse. So it's not shaking the structure all the time when the waves hit. So-
Nancy, I think you'll find West Hampton doesn't do the fill because they want to retain the original beach grass and natural growth in the area. Whereas when we fill, we do turf grass and ornamental shrubs and hedges and stuff, and do drastically change the landscape.
Yeah.
That's the biggest difference.
Yes,
You might
well-
have lattice work, but you'll have beach grass right to the lattice work.
Yeah, and we also have zones that the zoning board has to deal with, where you 150 foot from the wetlands, it has to be addressed for structure, 125 for landscaping, and sometimes they do better with buffers they put in that work better, but we try limiting the turf. And there's been times where DEC has met with me, showed me some aerials where somebody has aggressively put in sod, and I've gone down and told them they need to pull that back and get the beach grass back in. So we also do that too, to make sure we're not destroying the ecosystem of the dune structures. So that's what we're watching also.
What does AE and VE stand for on this map? Stupid question.
Well, VE is a velocity zone, and AE is just a lower zone where you have less wave action to worry about. So that's why the grades are lower on them. Okay.
Okay. You guys have a understanding of the starting point and where we're at, and I appreciate you coming in and talking to us about this.
Yeah, you look at this drawing again, you look at the 53 versus 35, and you can see what the difference is. A good portion of that 53 is going to be below grade when they put fill around the house here.
I mean, 7.5 feet of that is below the road anyway.
Right. Yes.
All right.
Interesting.
Any further questions and stuff to John?
No, okay.
Okay.
Shows a lot of clarity.
All right. Thanks, John.
Does it handle this the same way we do?
Yeah, it's good. Town handle. How does the town handle?
I think the town's pretty much on board with the same what we're doing. Again, each village has opportunity to address FEMA more aggressive or less aggressive, how you want, but as long as you're back in the federal program so they can get the insurance. Because some people call and they get upset if they're not getting that insurance. So they're basically the same also. As you know, the town trustees have problems with bulkheads, which, I just issued 3 more. I got 1 more bulkhead permit. The bathing court, Condren, the house next to Fowler Beach, that's just west of that. And there's one more, next to the bathing court, there's another house just east of that. So, and we're about maybe 87 or 90% bulkheaded within not the Meadow Lane district out there on the point, but east of that. So,
Basically from Halsey Neck east.
yes, correct. We don't want to see them out on Meadow Lane
Right.
because they do have the washovers there.
Okay.
And DEC does meet with me every year, and we go over our permits. That one time they thought we had a problem, and they couldn't find anything wrong with what we were doing, so they said we're okay.
Well, part of the charge to the planning commission is to look at what the other municipalities are, how they handle this. So everybody's impacted by this.
Right.
Okay.
Okay.
All right, John. Thanks.
Thank you.
Thank you, John.
So we've got any further comments from the board here in reference to this? Rick, do you have any comments? Okay. We're going to go through the list, and after I've called everybody's name.
I would just add that if the moratorium is adopted, the existing practice would not be allowed during the period of the moratorium. Under the moratorium local law, you have to measure from the existing natural grade, no matter how much you might be raising the grade to a finished grade. So the moratorium will put a temporary hold on that until the board has an opportunity to study all of the ramifications and decide in what manner you want to amend the zoning code to change the height regulation.
It's, but again, like the example we brought in here, the existing natural grade is at 7.5 feet. So it's so we're working off ground zero, which is sea level. That's what we're working off of.
That example would not be able to get a building permit during the moratorium.
Right. They would have to come to this board for relief.
Yeah.
That's what they would have to do. There's a process in place in the moratorium which will allow applications that don't fall on us to come in front of the village board for relief. So it's not stopping everything. It just allows another look at it. So, okay. That being said, Neil.
My name is Neil Smith. I'm a resident. I live at 466 Gin Lane in Southampton. I hope to set two precedents in speaking first tonight. I hope to. The first one is that I hope to speak for 3 minutes or less. I know we're not compelled to in this part of the meeting, but I'd like to try because I know you'll have a very long meeting otherwise. And I also, very specifically, don't want to talk about any current applications as you've requested, Mr. Chairman. So I'm going to try. I won't do that either. When I first moved into the village, I actually thought, funnily enough, there was nothing wrong with the planning law. And the moratorium actually sounds awfully like the way I read the planning law when I first bought my house. I was probably one of the few people who do read the planning law when they buy the house. But, I actually did do that. I think, though, I came to learn that what I believe is actually written on the piece of paper is not the way it's interpreted. So in many senses, this could be an interpretation issue and not a law issue. That's for you all to try and figure out. I think it's very brave of you going ahead and considering this moratorium. And I think you'll see tonight that regardless of what everybody's views are, there's a lot of different views, and it's something that certainly needs to be considered. I think you've heard very capably from the building inspector that under the current interpretation of the law, that would mean that you can actually build a house 54 feet above grade if you are in the VE 17 code.
That's not correct. No, from sea
From
level.
sea level. Well, it
Yeah.
depends. If grade's at sea level,
Yeah, but
then you
most-
can.
Yeah, you're right.
Yeah.
But that's an important piece.
I understand.
that
But
people have to
in many
understand.
cases, as I think you'll see in the village, grade is pretty close to sea level between the lakes and between the pond and the ocean, you know, and with the setbacks.
Yeah.
There's
But
not
it's-
much difference. There's one or two, but you're absolutely correct. I'm sorry, I should have clarified that. So, you know, the current law allows that to be permitted. So what effect does that have? It has the potential effect, for example, of bringing a completely conforming swimming pool into the shade for about 40% of the day. It has the potential effect of having what I would call a ground floor. It's actually the second floor, but the first floor is unusable under FEMA, so I'd call it the ground floor. It has the effect of having a ground floor actually looking down onto the bedrooms of an adjacent house. Now, how can that be? It happens because we're in a historic district. In a historic district, most of the historic buildings don't comply with the FEMA code. They can't, because when it was built, the FEMA code didn't exist. That creates all sorts of problems. So it creates height issues that, under the interpretation of the code, can cause you know, very difficult privacy issues to neighbours nearby. I think also it creates issues in dealing with potential neighbours that you know you need to. It would be great to be able to sort through. It puts people in the position of arguing that in order to be neighbourly, we should build a flat roof rather than a gabled roof because it would have less impact on you. The shadow over your pool wouldn't be as great. And that's, you know, if you go up to the 54-foot height, it's obviously far greater than the 47 feet height, if at grade. I submit that there's something, you know, very clearly wrong with that. And my house is a few hundred yards from perhaps the oldest part of the historic district. I mean, Old Town Road is called Old Town Road for a reason. The very history of Southampton is within a few hundred yards of my property. I just want to finish with three things, because I said I would be short, and I will be. I think, and this is important to me, it may not be important to you, but you'll hear tonight views from a lot of different people. You'll hear views from people who are residents, you'll hear views from people who are paid advisors, and you'll hear views from people who are prospective residents who, under my contention, perhaps don't fully appreciate the history of this great village. I would ask you to sort of make a note of it may not be important to you, but it's important to me. I would ask you to make a note of the status of the speakers as and when they speak. I think the second thing that you'll hear is that the moratorium. Sorry, bear with me a second. I think you may well hear that the moratorium will force people to build a different type of house. It may well, but that's not an issue for the moratorium. That's an issue for a later date. So I think the issues of the moratorium about, you know, whether or not you should actually consider it, not the issues of changing the planning laws themselves. I think that's a pretty important distinction. You may also hear that you don't need to change the planning laws. They already exist. I do think it's the interpretation of the planning laws, and I would ask that you put the moratorium in place. It's got safeguards built in, I understand, or it will have safeguards built in, and consider. A lot of the other villages, as I think you'll also hear around here, don't have the same interpretation of VE and FEMA as we do. And I think it's worth your while considering and seeing if the laws need updating and taking any ambiguity completely out of the law. Thank you for your time tonight. I know it's going to be a long night, and good wishes to you all.
Thanks. Mitchell Jacobson.
We've got Mitchell and my wife, Kathy. So good evening, and thank you for recognizing Kathy and me and providing us time to comment on the moratorium. Kathy and I purchased,
Your residence, please?
pardon?
Your residence, please?
320 Murray Place.
Thank you.
Sure. Kathy and I purchased a 4-acre piece of land at 320 Murray Place in May 2013. This purchase followed a search for a home for my family that stretched 7 years. It was the perfect location to build our dream house. We did extensive due diligence prior to the purchase and worked with architects, attorneys, and village officials to be certain that we could build our dream. We received a letter that I will hand to all of you that confirmed that we could build the house that we desired. The letter was signed by Mr. Foster, Chief Building Inspector, and I want to quote a relevant part of that letter. In quotes, "As you will see from the survey, the existing house currently meets dune crest and coastal erosion hazard area setbacks and is located at approximately 12 feet above mean sea level. A flood elevation certificate for the premises was prepared by Squires, Holden, Weisbacher, and Smith, dated December 4th, 2012, a copy of which is also enclosed, indicates that the building is currently in flood zone AE 15. Thus, as I understand it, the elevation of the lowest structural member above mean sea level needs to be 17 feet. The 15 feet that FEMA requires, plus 2 feet New York State freeboard. We would like to confirm with you, as has been the previous practice with the building department for as long as I can remember, that the height of any new dwelling to be constructed on the property in the location of the 12-foot elevation be measured from a point 17 feet above mean sea level because of above requirements, and that the maximum height of any new such dwelling would be 35 feet above that point, or an elevation of 52 feet above mean sea level. I believe that this would be consistent with previous interpretations of the village code in similar situations. We relied upon this letter, and we relied on council, and we complied with all village rules. You'll note that the date of the letter preceded our closing and purchase of our property. We purchased the land in reliance on village rules and a letter signed by the Chief Building Inspector. Upon purchase, we went to work with Haynes Roberts to design our home. We've invested considerable time and money to get to the stage that all permits are filed, and we're actually scheduled to have our ARB hearing September 8th. As you can imagine, as a family would do, we've agonized over the details. We spent countless hours looking at various designs, and we built our plan to be in our home 2 summers from now. While my age of 63 by no means feels old, nor has it diminished my excitement for this project, a delay at this stage will cost me a summer. And frankly, I just don't have enough summers left in my life. So when Kathy and I look at this, we ask, how can this be fair? We purchased land in a very private neighborhood, isolated from the main road and main beaches. We designed our home consistent with the character of our neighbors' homes. We followed every village rule. We relied on the rules and a letter from Chief Building Inspector to work to build a plan that would build the home of our dreams and allow us to enjoy the property in 2 summers. Now this. We don't think it's fair, we don't think it's commercially reasonable, and we don't think it's advisable for the village. We'd like to ask this board how they can even consider changing the rules 2.5 years after we received this letter signed by the building inspector upon which we based our purchase. How can the village consider changing the rules 2 years after we closed on the property, invested our time, our emotions, our energy, and our money on our family's future? I respectfully ask that this board do what is fair, commercially reasonable, and right, and reject the moratorium. Any delay on this part of group would unfairly delay our project and cost us valuable summers in our home. We thank you in advance, and we thank you for your attention. And if you don't mind, we just hand you letters. We've done it? All done. Thank you.
Thanks, Mr. James. Evelyn Conrad.
Of course, there are inequities at times like this when you change when you change a law. However, it's a little bit as if the Titanic is sinking and you're worried about the deck chairs. There's so much more wrong here than the height of the buildings. There's so much more wrong than the size of the buildings. There are the notice requirements, which are sham, which make it impossible for any group of people in a neighborhood to make a reasonable proposal against what is being offered. There are the sham ARB meetings. There are the prior agreements. We've just heard of one before there is an ARB meeting. There is so much lawlessness that it's difficult to know where to start. But the moratorium is not the place. First of all, the ordinance, the building ordinance that you have, the zoning ordinance that you have, is totally illegal. It was passed, the amendment was passed without any minutes, which is a violation not only of the Open Meetings Law of 107.3, but also of the Village Code, Chapter 7, 706. So there is no statute of limitations problem. There is a problem of a very lawless administration that has to be stopped. I think the entire village is suffering. Residents are getting very impatient. We're planning a grievance hearing on Sunday at 4 o'clock. I would like to invite the Southampton Association to assume the leadership position that it rightfully should have and has as a civic organization and join us. I would like its lawyer to join us. I have documentation for everything that I say, much of it out of Bill's files, much of it on record, much of it in court. The solutions at this point, in my view, are not a moratorium. There are political solutions and there are judicial ones. Frankly, my dear, I don't care which one we do, but I do know that what is happening in this village now has to stop. And I'm glad I have a chance to talk to you about it again, although I've done it often. I hope this time there's a larger audience and that people will come to the grievance hearing at 4 o'clock on Sunday. We're inviting Southampton Association to provide a hall. If they don't, then one of the churches will give us the space. Everybody here is invited. The problem is acute. Thank you.
All right, John Bennett.
Thank you for the opportunity to speak. With me this evening is Bailey Larkin, my associate, and she's going to hand up a letter that I've submitted or will submit for the board's consideration, as well as letters from some of my clients. I won't go through the list of clients. There are 10 clients that I represent, and I'll leave the letter for that for the identification of the clients. Before I talk to you about what I think is the unreasonableness and inapplicability of the law of this moratorium, I want to make sure you understand how extreme an example can be. It's an extreme example, you may think, but it's not an unusual one. Let's make sure about what we're talking here. You have a Federal Emergency Management Agency rule which has been passed for the safety of everyone that lives not in the flood zone, not only for the safety of the house themselves, but at that particular property, but as Mr. Foster explained, so that portions of property don't become used in effect as a battering ram on adjoining properties. Let's take an example. Say that you're in a VE, a velocity zone 18. It's not unusual. And then you have a 2-foot freeboard requirement, which the state building code requires. That means that in a VE zone, your lowest structural horizontal member, that's the bottom of the girders, has to be
John,
20
you want some of these back? I ended up with
20 feet above, Bailey, if you want to. Thank you. That means your lowest structural member has to be 20 feet above sea level. Say your grade is at 9, which I think I'm being reasonable, because that's I'm not being chintzy with my example. If your grade is at 9, that means and your base flood elevation requirement is 18 plus 2. That means the lowest structural member has to be 20 feet above sea level. What does that mean? That means under the village code provisions that are being proposed for the moratorium, for a flat roofed house, 27 minus 11, 60, you have 16 feet to build a house in. Or a pitched roof house, 35 feet, you have 24 feet to build it in. If you're going to say that that's reasonably acceptable or fair to any one of my clients that have purchased a property, I don't think anyone would say that that's reasonable or fair for any period of time. Let me talk to you about the moratorium and the law that surrounds the board's ability to grant a moratorium or enact a moratorium. And I've given you the case law, so I don't want to go through the specific names of the cases, but I want to quote you from some of the cases. It has to be a building moratorium, in order to be upheld, must be reasonable, necessary, and a limited response directly addressing a genuine crisis or emergency. This is from the case law. The municipality may not evoke its police powers solely as a pretext to assuage strident community opposition. I don't, if people want to laugh at the appellate division language, the second department, which is where we are, which has been affirmed by the Court of Appeals, I guess that's their right. But I'm reading to you from the case law. A stopgap measure to halt temporary development of further density-producing development may be considered reasonable. But here, the moratorium is an exceedingly broad moratorium on building, including retrofitting, to comply with FEMA height requirements, even on existing lots. It makes no sense at all. Just let me contrast for a second what the town of Southampton did. The town of Southampton passed a law recently on May 27th that said if you want to have an existing house, no matter how high it is, no matter what its conformance is, and you want to raise it to conform to FEMA, they give you automatic pyramid encroachment and maximum height relief. You're talking about going the other way. It makes absolutely no sense whatsoever. And in terms of what some of the other municipalities do, Sagaponack, base floodplain +2, that's where you start in their code, 32-foot height limit. But let me go back to this case law. There's a very interesting case in the second department, which is where we are, involving the village of Tarrytown. People were concerned about the height of cellular towers. So they lobbied for some sort of law against it. The plaintiff applied to construct a cell phone tower. In August of the year, several members of the ZBA informally indicated their intention to approve the application. And that was in August. Less than a month later, the Board of Trustees adopted a local law imposing a moratorium on the installation of these antennas after significant political lobbying. Does this sound familiar? Sure it does. That's exactly what's going on here. What did the appellate division do to it? The appellate division said, in throwing out the moratorium, it was clearly not adopted for proper and reasonable purposes of responding to a genuine crisis or dire necessity, nor was it reasonably calculated to alleviate or prevent a crisis situation. They were politically assuaging a certain vocal minority's claim of harm. That's what's happening here. People may argue differently, but that's exactly what's happening here. The moratorium ignores significant reliance of all of my clients on a 30-year-old interpretation of the building department, which interpretation was acknowledged by the village attorney in public, to his credit, and has been acknowledged in writing on numerous occasions by the building inspector, to his credit. This is a substantial property right. The moratorium makes it impossible to reasonably build in the vast majority of lots affected, and at the same time comply with a very significant FEMA regulation. I'd say you might be putting your community rating in jeopardy, because what you're doing is telling people that you can't even raise a house to comply to FEMA. This is a bad idea. And the record is clear. What you're doing is you're unwisely elevating a small vocal group's aesthetic choices, because you know something? It's not about height, it's about aesthetics. And their attempt to foist those aesthetic choices on others over two significant elements: significant established property rights and the health, safety, and welfare dictates of the FEMA code. You shouldn't be doing this. It's an improper use of your police powers, and it's clearly contrary to what the courts have said. And I was going to talk about the referrals that must take place, but I'm glad to see that you're not acting, because it seems clear to me under the General Municipal Law, Section 239, that a referral has to be made to the County Planning Commission. I also noted under your code, under your own code, that a referral has to be made to your own Village Planning Commission. That may or may not exist. I was somewhat chagrined today when I asked for a copy of it, and I was told that I couldn't get one. I don't even know if it exists, but I certainly think that should be put in the record. So if you simply look at what is going on here and be fair to people and read the law and rely on the very good and wise counsel of your attorney, I think that you'll find that this is not an appropriate use of the moratorium powers. If you ignore that and decide to adopt the moratorium anyway, and which we again object to, the moratorium should not apply to any property owner who has taken title to the property before the effective date of the moratorium. That's not unusual at all. Keying applicability of ordinances and local laws into the date of obtaining title is not at all unusual. So, for example, in your own code, 116.19 of the Village Code, lots that were lawfully existing prior to the effective date of the code enjoy significant grandfathering provisions. It's simply not fair. I think it just goes back to something really basic. How many times when you were playing as a kid, when you're playing a game, playing sports, anything, you know, what did Churchill say? The battles are won on the playing fields of Eton. The guy you really got annoyed with is the guy that changed the rules of the game in the middle of it. And that's what you're doing here. It's just basically gut unfair. Not only that, the law says it's unfair. The town approach, as I said, is in the right direction. They give you automatic relief when you comply with FEMA. So you have to ask yourself, why are we doing something to the contrary? How serious and urgent are the circumstances? Somebody's aesthetic is offended? That's not a crisis. That's not urgent. What hard evidence is there to document the necessity of it? Are there any other alternatives less burdensome on the property rights? If you have an idea about what you want to do with property rights, do what every other municipality does. Put a number in there, set it down for a public hearing, and see how people respond. Don't put people in this ridiculous limbo of not even knowing how they can design. And yes, you say there's going to be an exemption provision, but you know very well that at every exemption application is going to turn into a political mess, because people are going to be here saying, if you give one exemption, you'll just be like throwing the moratorium out, and there'll be an immense amount of political pressure on you not to grant any exemptions. So the exemption provision is a bit of a chimera. I suggest to you that you do the right thing. You let these people rely on the property rights that they established when they purchased these properties in good faith, not willy-nilly. These are all very expensive properties. Every one of the clients was either represented by me or a very competent land use attorney before they purchased the property. They relied on this in good faith. Don't take that good faith away from them. They're taxpayers, they're citizens, they're community members, and they deserve your support. Thank you.
Steve Angel.
I'm Steve Angel, Essex Heffern Angel in Main Street in Riverhead, and I'm here on behalf of the new owners of 22 Gin Lane, and the name of their company that owns it is Beck and Alex 22, and it's an LLC. I signed up at the wrong time. John made the impassioned legal argument, and I'll try to just focus a little bit differently. And I don't want to talk about the details of the code. I just want to talk about the moratorium. And I want to start out with what I consider the less important aspect of my little speech here, and that people alluded to it, but the way your broad moratorium, the way it's drafted, is going to probably have a chilling effect on the goals of the FEMA program. For example, if somebody has a house that's located in the, let's say on the wrong side of the coastal zone erosion line and wants to move it, and obviously has to raise it to another raise it when he moves it to another portion of the property that's more conforming for safety reasons, won't be able to do it without that hardship application during this moratorium period. And the same is true for alterations that are required. But what I think is more important to focus on, and that John hit on it, is that this is a property rights issue. What you're telling people is that for 6 months from some soon-to-be future date, if you pass it, they can't do anything with their property. And these are people, as John pointed out, that have invested a significant amount of money in one of the premier villages in the country, who've paid their Peconic tax, who've paid their large amount of money, who are now paying taxes to the village, and have the reasonable expectation of being able to use it for a very normal purpose, it's to build a single-family home. We're not talking about a moratorium on a commercial development of big box stores that are going to come in and change the nature of the community. There's no substantial change to the nature of a community. What you're just talking about is the height. And it is a major property rights issue. And I think one of the things that hasn't been mentioned yet, and I want to focus on that just a little bit, is that you're dealing with a very discrete problem: how to measure the height in these particular FEMA-influenced zones. And you're dealing with that discrete issue, not a big planning issue about big box stores or something like that, with a discrete issue with single-family homes. And you're potentially dealing with it, should you pass this moratorium, with a very powerful, very injurious remedy. It's not like you're taking 6 months to do a comprehensive revision of your zoning code, to do a comprehensive revision of the commercial code. You're taking 6 months to determine whether it should be the 42-foot level above sea level like the town, or something in between, or something like Sagaponic did. Why stop people from using their properties on this discrete issue when it's not a comprehensive revision that you're looking at? There's just no justification, given the discrete problem, to take a 6-month time out and take away people's property rights to study it. It's not. It's a discrete problem that can be resolved without this drastic remedy. And again, just to add and summarize, it is a property rights issue. People who invest a substantial amount of money to build their houses have a reasonable expectation that they'll be processed in the normal course of events. They don't expect a moratorium. Perhaps McDonald's coming into the community, who's had experiences in New York State with moratoriums, can understand that perhaps in certain circumstances. But the average homeowner sees this as or the average lot owner who wants to be a homeowner, sees this as a really brutal impact on their rights to do what their neighbors are doing. Now, I'm not saying don't study it. I'm not saying don't study and come up with another way of doing things or some limitation. That's not before you today. What I'm saying is don't take away people's property rights to make them suffer for 6 months and potentially longer if you continue it, like many moratoria. Don't take that away from them. Look at it as a property rights issue. Think about it, what you would feel about yourself under these circumstances, and don't pass the moratorium. Thank you.
We have a letter from Diane and Bruce Grossman. Are they here and would like to speak? I think we have a copy of it already.
I'll read it into the record. Dear Mayor Epley and members of the Board of Trustees, we're the owner of 450 Gin Lane, Southampton. We write this letter to request that you not enact the proposed moratorium on construction within the flood zones of the village of Southampton. We apologize for not being able to be present at this hearing. We hope the board will not mistake our absence as an indication that we are treating this matter lightly or without serious concern. Indeed, the matter is very serious insofar as we have invested a great deal of time and money and emotion in the property based upon our proper and responsible due diligence prior to our significant purchase. However, we have opted to take our son to his freshman year of college over the next few days, a decision which we are sure you would expect from homeowners who consider their roles as responsible parents paramount and primary. Nevertheless, we wish the board to be aware of our surprise, consternation, concern, and dismay at this proposed moratorium. We feel that were responsible and proactive and investigated the height requirements in the village prior to making such a substantial investment. We think it is patently unfair to stop us in our long-held dream of building a house on the ocean on Gin Lane in Southampton, particularly when we were responsible in our investigation of the allowable building envelopes and height limitations. We made sure that the house that was on the lot benefited from a demolition permit, and we obtained relief from the Zoning Board of Appeals for a design that is in the building envelope that is very protective of both the dunes and the wetlands across the street from Old Town Pond. We understand that there are exemptions in the proposed moratorium. These provisions have language which is very broad, and we submit do not present a homeowner with any predictability or any clearly objective standards for how to make decisions. Our decisions to purchase 450 Gin Lane, made with considerable joy for our family, to be able to enjoy a house in this wonderful village, has now become a source of great anxiety for us. At a minimum, we object to the moratorium, but we request that you expand the exemptions permitted in the proposed moratorium to provide for automatic exemptions for any property owner who took title prior to the effective date of the moratorium. We simply think that it is unfair and improper for the board to paint with such a broad brush, if by the mere stroke of a pen, legislation that will jeopardize our well-informed investment expectations and put development of our property on hold and in limbo will be visited upon us. Our understanding was and is that the village has for over 30 years calculated the allowable height in the flood zones in a certain manner. The height requirements have been established by the Federal Emergency Management Agency, we understand, to protect not only our property, but the surrounding properties from flood damage. Requiring building in the vertical envelope established in this moratorium punishes the property owner from attempting to construct in a manner that provides protection in the unfortunate event of flooding. We would, to be honest, not be so chagrined if we had entered into what one would consider a risky investment. To the contrary, we were responsible, reasonable, and did our homework. To have someone change well-established rules is unfair and contrary to the rights of citizens and taxpayers of this village. We hope to embrace this wonderful, historic, and lovely community. This has been a harsh welcome, and we ask you to reject the proposed law and remove us from this unfair quagmire. And that's Diane and Bruce Grossman.
Great, thanks. Mark Fish. Same.
You know, I'm going to ask my associate Bailey to read that so you don't have to listen to my voice for
Thank
another
God.
5 minutes.
This is from Rachel Davidson and Mark Fish, owners of 1370 Meadow Lane in Southampton. I write this letter as a property owner and taxpayer in the village of Southampton and in response to the proposed moratorium the village board is considering. I own a residence at 1370 Meadow Lane, which I had planned to expand. I have already met with the village building inspector to discuss my proposal and had intended to begin the village review process imminently. My plans will be derailed should the village board choose to enact the proposed moratorium. Please accept this correspondence as my request that the board vote against the enactment of the proposed moratorium. I have invested a great deal of money, time, and effort in designing our proposed renovations. It would be unfair and improper of the village board to prevent village residents from moving forward with their thoughtfully considered renovations. As an owner of a property that directly overlooks the Atlantic Ocean, I am aware that the Federal Emergency Management Agency's height restrictions have been established to protect not only my property, but those of surrounding properties from flood damage. It is also my understanding that the village has for over 30 years calculated the allowable height in the flood zones in a certain manner. Our community has been significantly impacted by storm damage over the last few years, and many are still recovering from the damages incurred. It is difficult to rationalize the board's objective in enacting the proposed moratorium. By creating the height limitations outlined in the proposed moratorium, the village essentially punishes a property owner for attempting to construct in a manner that provides protection in the event of flooding. Furthermore, while the proposed moratorium provides exemption, I find there is no clear standard of review for submission of such a request. I request that the board vote against the enactment of such legislation. If the board does choose to enact some version of the proposed moratorium, while I still object, I would request that you expand the exemption provisions to include an automatic exemption for property owners such as myself who took title prior to the effective date of the moratorium. As a resident and taxpayer in the village, I urge the board not to enact the proposed moratorium. If it is enacted, I will be prevented from completing the renovations I have long desired.
Adam?
Good evening. I'm Adam Taubman from the law firm of Kramer Levin of Tallis and Frankel. We represent EAM 40 Meadow Lane, LLC, the owner of 40 Meadow Lane. I'm here to read a letter that my colleague Jeffrey Braun submitted to the board yesterday. He unfortunately couldn't make it here tonight. And since I know we're limited on time, I'll make an effort to omit and modify certain portions as I go along. But before beginning, I should point out that although this letter makes some references to one of the applications, it doesn't at all reference the proposal itself in substance or any of the merits of that application. I write to express EAM's opposition to the proposed moratorium. I urge your board to reject the moratorium outright, or at least to defer action on it and to modify it in such a way that it will not affect EAM's proposed new residence, which has been the subject of extensive proceedings before the village's Board of Historic Preservation and Architectural Review. If adopted by your board in its present form, the moratorium will represent the successful culmination of a two-pronged strategy, whereby a handful of individuals, some of whom are not even full-time residents of the village, seek to impose their personal aesthetic preferences on EAM by improperly stalling final action by the Architectural Review Board, while simultaneously pressing for accelerated adoption of a moratorium that is aimed squarely at EAM. If these machinations succeed, EAM will suffer enormous harm and will feel compelled to seek recourse in the courts in the form of nullification of the village's actions and money damages from the village. The combination of ARB delay and adoption of a moratorium would improperly deprive EAM of the ability to vest its right to build its proposed new residence and to enjoy its property in accordance with its reasonable investment-backed expectations. In these sorts of situations, the courts have on multiple occasions provided declaratory, injunctive, and even monetary relief to property owners whose rights have been improperly interfered with. For example, in Pokawik v. Silsdorf, a Court of Appeals case, an owner sued to annul the decision of the building inspector and the determination of the Zoning Board of Appeals of the Village of Ocean Beach, which had denied the owner's application for a building permit. In that case, the village had wrongfully delayed a hearing on the owner's appeal from an adverse determination by the building inspector, while the village trustees amended the zoning ordinance. After the ordinance had been amended, the ZBA hearing on the owner's application was allowed to proceed, and the owner's appeal was denied on the basis of the amended ordinance. New York's Court of Appeal ruled in favor of the owner. It held, and I quote, "The village used dilatory tactics to discourage petitioner from seeking the building permit to which he was entitled by first refusing to act on his application, and, after court proceedings directing it to act, delaying action still further. In addition, when he was finally progressing with his appeal, an amendment was passed which would serve to cut off his rights. This administrative procrastination, calculated to deny a property owner his right to use this land in a currently lawful manner, is supportable neither by law nor by sound and ethical practice. Therefore, the court annulled the board's decision as arbitrary and capricious." Other decisions of the Court of Appeals have established the rule that where officials who prevent lawful construction are motivated by improper reasons that include political concerns, their actions may be deemed an unconstitutional deprivation of defendants' property rights, giving rise not only to annulment of the municipality's improper actions, but also an award of money damages against the municipality. If adopted in its current form, moreover, the proposed moratorium would have a severe adverse economic impact on EAM, given the millions of dollars of contractual obligations that EAM has incurred, and the inability to develop this property in accordance with a plan that has received favorable consideration from the ARB on the merits and has been determined by the Zoning Board of Appeals to comply with applicable FEMA requirements. For these and other reasons, your board should not adopt the proposed moratorium in its present form. It should either reject the moratorium in its entirety or defer action on it while appropriate changes are made to the proposed law. Thank you.
Thanks. Melvin Heller.
My name is Melvin Heller. I live at 1532 Meadow Lane, after Road D. I moved to Southampton because I love the beach, the village, and the view. If we ever pass a moratorium and I had to rebuild my house, I would not have a view. My dunes are very, very high. They're very, very protective. I built an add to them, but I would not live on Meadow Lane or not live personally in Southampton if I did not have a view. Our properties are very, very restricted. We have so many lines that we can't cross. We have to be 50 from here, 100 from here, 150 feet from here. So the comment that we're going to cloud somebody's swimming pool, I don't understand it. We're so far away. Our houses are much smaller than our property. I have 4 or 5 acres, and my house is about 8,000 feet. That's on both floors, total. I don't have a basement. Imagine if I said, all the village, no basement, 20 feet high, and you suffer with us. With what's happening with all the floods, et cetera, it's obscene not to count that line. But I also respect other people's opinions, so I took a very slow drive down Meadow Lane from Row D. The houses are beautiful. I would never live in West Hampton. It's all filled up, the foliage. My house has all natural foliage. There is no reason to think aesthetically there's anything wrong with it. Not that aesthetics should be the reason. We have a special board that decides, the architectural board. But based on that, we also pay tremendous amounts of money, tremendous amounts of taxes, and support the tremendous construction industry. So it's not only us. I'm just pointing out that there's other people in this village and the village that will suffer as a result. And also, even though my house is built, I empathize with the people who say, who bought property and can't build. It's like, not in my backyard. So I think it's totally unfair to stop them. And also, as far as historic, if you look at Meadow Lane, the houses are beautiful. They're very fitting. This is not a 300-year-old area. 30 years ago, there was a couple of shacks on Meadow Lane. And take a look at it now. It's all beautiful, respectful, and I appreciate certain houses I don't like. But I'm not going to penalize an entire village or everybody who puts all that money and effort into their properties for not liking 2 or 3 houses. Thank you.
Thanks. Rob Hayward? Rob Hayward, yes. Yep.
Thanks for being able to address you. I'll keep it relatively short. I'm a property owner of 477 First Neck Lane. I did my homework like many of my colleagues here. I don't know why you can change the rules. I mean, we spent 4, maybe even 5 years trying to find the right property. We found a property with kind of complexity in it because it was in wetlands, and there's a lot of restoration to be done. So we decided, as sort of awesome, exciting potential new owners, to really rebuild the wetlands. So we've committed to a very significant undertaking that probably comes to good to everybody because of the freshwater stuff and so on. And we want to move here with our family. So I don't really understand what's going on here. So I'm very disappointed because this country, and I'm Belgium, so I live here for work purposes, and I'm going to come and live here permanently. I don't understand why you can just change the rules. It's beyond me. I think you have a rule of law here, and it's just completely unfair. Thank you.
Tom Dean?
I'm a resident of 20 Meadow Lane, and I guess one of the great things about this country is we do have different points of view, and I think you'll start hearing about some of the different points of view. I do think we have a crisis in this village, and it's sort of the rule of unintended consequences. FEMA raised their levels for the appropriate reasons that FEMA concluded, and we've added on top. What if FEMA comes back tomorrow and says there's another 15 feet? I should probably tear down my house on 20 Meadow Lane and build a 75-foot house. This is the consequence of sort of somewhat mathematically applying a statute that's in constant flux without any regard to the consequences for neighbors and communities. One of the gentlemen talked about the fact there's lots of space between properties. You know, I face the prospect of having a house that's 15 feet higher than mine with balconies 11 feet from my property line, looking into my house. I think at the very least, this board really deserves, and the people in this town and village deserve proper consideration of the consequences of what FEMA has done and what new architecture has brought in and allowed to happen. Otherwise, this place is going to be a very, very different place. And I do think, you know, there's different points of view. I respect the property owners' rights to do what they need to do, and I think there's a mechanism in the moratorium to allow them to do that. But I think just blindly applying a FEMA rule that can change and has changed over the years quite dramatically, I think is a recipe for disaster.
Thanks.
Thank you.
Jay Belaski?
Hi, my name is Jay Bialski, and I'm presently the current owner of 2 vacant properties in the village, 20 Gin Lane and 24 Gin Lane. I own them under JV 20 Gin Lane LLC and JV 24 Gin Lane LLC. I bought them with the intent to construct 2 new residences on the lots. I've invested a great deal of time and money in acquiring these parcels. My substantial purchase was only completed after I properly and reasonably researched the potential for development of these parcels. And if the board votes to approve this moratorium, it will create significant financial impact for me. This is such a quagmire for all of us. If a person buys a piece of property and we do our due diligence and we know we have rights, and then we spend millions of dollars buying the properties, and then we go to spend hundreds of thousands of dollars on architects, and we're ready to design and submit, and you can't. You've put me at harm. You've put other landowners at harm, and it's very dangerous and it's unfair, and it's going to cause a real problem for many, many people. And I just ask you to not go forward with the moratorium.
Okay.
Thank you.
Mackie Finnerty.
Good evening. Considering a moratorium, people are acting like it's the most amazing, outlandish thing that ever happened. They happen all the time. Just turn on the news. Practically every day there's some kind of moratorium here or somewhere in the world. I lived 2 blocks from a moratorium when I was in Washington, D.C. That was imposed for a very good reason, and everybody who had an interest was up in arms, and like, oh my God, I've lost all this money, and what am I going to do? And I invested all the property, all the things we're hearing tonight. In fact, it was an excellent moratorium, and it hugely improved the area. And when it was finished, everyone's property values went up, both commercial and residential. So moratoriums are there for a good reason. They're to stop a difficult problem that's happening and get a solution to it, so that you don't have something that's hastily written. You want to take great care with this. It's a very difficult problem. People are acting like how surprised they are that our law changes. As you know, the Supreme Court, which does about 60 cases a year, changes our law every week, if you figure it out over the year, and we all live with it. It's not the end of the world. It does change your investments. It changes the value of things that you own. But it sometimes makes improvements, sometimes it does not. People also tonight felt that height is not an important thing. The height of buildings controls what a whole town actually looks like. Again, D.C. being an example, they have probably the most famous height restrictions in the country. And it's what makes it such a beautiful town. We don't want houses. We know FEMA's going to keep changing this because we all know that the waters are rising. I mean, we know we're in global warming. You just go down to the beach any day, go down to the marshes, ask the people on the reservation where the water was and where it is now. This is going to change. FEMA has to keep changing this. They have no choice. People also seem surprised how dare the federal government ask this. They dare ask it because all of us are the ones really paying for that insurance. They pay a premium. They might pay $300,000 on a $20 million home. Guess who's paying the rest if there's a hurricane next fall? Us, every one of us in this room. That's why it's so important. That's why the federal government has to be involved in this. It's the whole coast of the United States down both sides involved in hurricanes and rising waters. And they should keep up with the times, and they need to change it. And it does create a problem for us. But I have confidence that you can come up with something that's reasonable. Maybe people will build different houses, maybe lower and longer houses. Every law that's passed helps somebody and hurts somebody else. You've heard people here speak tonight. I've been at all the architectural review meetings this whole summer, and people have been talking about when you do this kind of house that you want and you can't live without, the neighbor next door has a glare from all these new materials, from all the glass work, where all the balconies are staring into their swimming pool. They can't even use their patio anymore. So what's a beautiful home to somebody is a problem to somebody else. And it's been eloquent. If you look at the record of this summer, you will hear argument after argument about that. I'd like to know, you talked about there'll be grounds for a variance. One of the problems I'm sure you all hear a lot about in the village is it seems that almost everybody gets a variance for whatever they want. It's important when you write a law that you write in some parameters for what that variance would be, because everyone has a hardship. But, you know, a hardship in Southampton is not a hardship pretty much everywhere else in the world. So, though many people tonight have felt that if they can't build the latest $20 million second or third or fourth home on our beach when they want to, that's a tremendous personal hardship. Well, I'm sure it's annoying. It is annoying. We all have our dreams, no matter what our economic level, and we want to have those dreams come true when we want to have them come true, and we're annoyed if they do not. But I don't think a 6-month moratorium, while all of you get to think really hard about what's the best thing you can do about this for the beauty of Southampton and to protect people's values, because we don't want to look like West Hampton Beach. We don't want all these monster houses just looking down on you at the road or the beach or wherever. We do want to preserve the beauty as we have it, and it's going to take a lot of hard thought in order to do that. Another problem that has not come up this night, but from previous hearings, whenever we've had these hurricanes and everybody analyzes what happened, where was the big damage, is every single structure on the beach affects the winds and how they move, and affects the waters and how they move over the land. We notice in our town that there's whole sections that were hardly hurt at all in that last hurricane because they didn't do the shore hardening. And we noticed the areas with the shore hardening were hit much harder. In an attempt to protect their own property, they actually destroyed a lot of their own property and other people's property as well. So every time, if you're going to allow higher and higher and higher things on the beach, it will be affected by the winds and the waters as they move over in the hurricanes that we know we're going to get and have always gotten here. So I hope when you look at this, you will have somebody who's an expert on that, of which there are many out here, who are often testifying in cases of what will be the effect if you let things go to 60, 70, 80 feet. What will that do to everything else environmentally? We hope the applicants will still move here. We'd like to have them in our village. They all seem like nice people, and I think we can come to a compromise on this. Thank you.
Lucy Howard. Okay. Philip Howard.
We're not even related. Good evening. Thank you again for holding the hearing and for this proposal. I'm Philip Howard. I live at 63 Meadow Lane. We've heard a lot from the property owners who may be affected or their projects delayed by this moratorium, and I understand their point of view. And you know, I think I would be disappointed if I was in the middle of a project as well. But there are many other property owners also affected by the height of the buildings. The reason there is a 35-foot height limit for buildings that have complying gables is so that there is a uniformity throughout the district. One of the things that makes this village so special. And what's happened is not the result of a 30-year practice. It's the result of something that's barely happened, which is a raise in the FEMA limits of only a few years ago, of which you'd be hard-pressed to find a number of examples built under it on one hand, on the beach at least, you know, with the high 16 and 17-foot height limit. And this comes up because these houses are going to stick up much more obtrusively than the hodgepodge at West Hampton Beach. And it will, in fact, destroy the ambiance that all the other property owners have come to rely upon, and that I believe contributes to the value of this remarkable village. It is a hard problem because FEMA is requiring it to go up in certain beach areas, and it requires, therefore, if you wanted to keep the heights down, that the same size house has to be built on on a larger floor area and less high, which therefore it'll be dependent on the size of the lot, among other things. I'm not sure that's unfair. Those are the things you have to consider during the moratorium. But the existence of a height limit is not a mere aesthetic whim. It's been part of the code of this village for decades. And while it has been raised a little bit in past years as FEMA requirements went up, it has not been raised, and there's no pattern or practice of raising it up 15 or 17 feet. That's the reason why it's important to have this moratorium and to consider in a deliberate legislative way what the best strategy is for the village of Southampton. There's been a lot of talk about property rights. The law on property rights is quite clear. We're not singling out some owner and delaying his building permit here. This is a moratorium of general application in order to consider an issue of village-wide significance. The law is quite clear. Tom Levin has written an opinion letter for the Southampton Association that I think Jay Deasing will put in that states the law. It so happens that for 30 years I was counsel and then chair to the Municipal Art Society of New York, where we're involved in many zoning changes, many creation of many historic districts. Invariably, landowners said this will destroy our value whenever there was a zoning change or a creation of a historic district. In almost all cases, the Upper East Side Historic District comes to mind, it actually enhanced the value of the property by creating these coherent, beautiful neighborhoods that people wanted to be in. The last thing I would suggest is there's also been talk about the good faith of people, and I don't question good faith of people buying the lots, and there is a hardship application as part of this process, which is appropriate, but good faith varies case by case, and at least in one case that I'm involved in, I think there's a pattern of incomplete, misleading applications where one could not make the argument of good faith, and we would be prepared, therefore, to discuss that on the merits at the right time before this board. But at the moment, you don't want us to talk about particular applications. What's important, I believe, is to understand that this village deserves a deliberate legislative strategy of what the maximum height of buildings should be, in what circumstances, in an ever-changing FEMA environment, and given a fair degree of uniformity that currently exists with existing, probably hundreds of existing property owners who will be affected if all of a sudden these buildings start popping up that are floor or 2 floors higher than they are. That's why this is important. Thank you very much.
Thanks, Mr. Howard. Thank you. Alexandra Howard. Okay. Okay, Bruce.
Yes, my name is Bruce Bachman. I live at 660 Halsey Neck Lane here in the village. I've been a homeowner here for 22 years, and I have some prepared comments, but I'd like to just comment on this property rights thing. I've been here for 22 years. I've got a very substantial property. I've been maintaining it and keeping it up and maintaining its historic integrity and its position in the village for 22 years. And what you are thinking about putting in is nothing like what I've put in over these 22 years. I came home last winter and I found this house looming over me. It would reduce the privacy of my entire property, and it all turned out that it was sticking up so high because of the FEMA requirements. So I've got to think a little bit about what it does to my property as a representative of existing properties. Back on April 8th, I appeared before this board to express my concern regarding very large houses being built in the flood district in my neighborhood. These houses loomed over the neighboring houses and were causing severe stresses among the homeowners. The problems the neighbors were experiencing were a feeling of living next to a monster, a loss of sunlight, and invasions of privacy. There are also concerns about drainage and about the loss of floodplain that increase flooding in the older surrounding properties. If you build up on a floodplain and you build up to a height above the ground level, you reduce the floodplain, and if enough houses are put up, the flooding on the existing older properties, the problem increases. I was very pleased at that time and in 2 subsequent meetings with this board to see that they took these considerations very seriously and started looking into what they could do. And one of the things was determined by this board was that they would go ahead and move the issue into the hands of Planning Commission to see what should properly be done. It's now 4 months later. We've seen some very dramatic examples of the problems here with regard to the applications, which is complicated not only by the flood zone, but by the historic district regulations and guidelines. It's quite significant here that hardly anybody has discussed that part of the code so far. It doesn't suit their case. And in cases where everybody should have known by reading the code that there were historic district restrictions on what you could do, they should have taken that into account and not just the zoning when they made the decision to buy the property and go ahead. I think, importantly, we should remember what this moratorium is. This is not about what's going to come out at the end. This moratorium is about giving this village a chance to sit back quietly and take the time to deal with a very complicated issue, and we hope that when we're all through, we can get ourselves into a situation where these conflicts are at least reduced. They'll never be avoided, but they will at least be reduced. And that's what we're talking about when we discuss the moratorium. Everybody's trying to say it's going to come out bad. We don't know it's going to come out bad. It might come out great. And let's take that chance, but let's do it under circumstances where we don't have applications running in and beating everybody up. We're trying to make fast decisions on long-term issues. Let's take this moratorium, take the 6 months, and come out someplace which probably is much better than where we are. Thank you.
Lisa?
I have a signed copy, and I have a written statement and letter that I'd like to give each to you. Good evening. For the record, my name is Lisa LaQuarrie, and I'm president of Fine Arts and Sciences. And on behalf of the Southampton Association, I commend your proposal to establish this moratorium to allow the Village Planning Commission time to complete its study and to formulate recommendations regarding the permitted residential building heights pertaining to FEMA. And it's critical that pending and new applications be subject to the moratorium to prevent, now excuse the pun, but a flood of new approvals before this work has been completed. We've heard about a lot of applications that were pending, and yet between the time when these new FEMA regulations were adopted in the end of 2009 to now, there were 2 approvals on Gin Lane and Meadow Lane in the FEMA zones that needed to meet these regulations. One of them obtained a height variance. So there wasn't a lot, and all of a sudden now we see a surge. And that is really one of the things to consider as to why to include everybody. So due to the concern with these building heights, the Southampton Association retained my firm to review and compare zoning codes and practices in the 6 South Fork municipalities. And just by way of background, I'm an environmental and land use planner with 25 years of experience. 15 of those was the planning director for the town of East Hampton, and I helped to draft the FEMA regulations for that town. So excuse me for reading much of this, but there gets to be some very specific points that that's why I need to read. So basically, all municipalities with ocean frontage have FEMA, the VE zones, so there's the VE 17 and 16. There are also higher, but a lot of those aren't, or beyond, seaward of the coastal zone where you'd even be able to build. So if you can look at that last page of the letter, I've got a chart, and the first two rows across there, all the municipalities across the top, and the first two rows are depict what all the municipalities must do in the various zones. So in the VE elevation 17 and 16, you go up 2 more feet, as you've heard from your building inspector. You need to meet 2 more feet of freeboard, and that's a New York State Building Code requirement. So the state can go above what FEMA has, and that's what our state has chosen to do. So within the town of East Hampton, the village of East Hampton, and the village of Sag Harbor, the maximum height of a residence is measured from natural grade, whether or not the residence is located in a FEMA zone. Now, within the village of Southampton, you've heard how that's measured, okay? So you go to the FEMA zone +2 for the freeboard, and then you go from there. So, for example, in Meadow and Gin lanes, it's maybe 4 to 7 feet in places. The property may rise to 9 feet or something, but the roadways are even lower. And so the base height of residences on ocean-facing properties can be as much as 15 feet above the street level. That would just be the base. And then you put the 35-foot pitched roof residence on top of that, and that's where you get to the 54 feet. By comparison, in East Hampton Town, in East Hampton Village, and Sag Harbor, under comparable natural elevations, a pitched house would have a maximum of 36 to 40 feet above mean sea level, depending on the municipality. And that's also written right there in that code, that first row. So now, in the town of Southampton and the village of Sagaponack, there is specific language in the zoning codes which permit the maximum height to be measured from the FEMA heights. So again, they're doing the FEMA +2, which that's required by the state. But what they also have is a maximum cap of 40 feet above sea level. So whereas your base height is going to be the FEMA +2, then you can only go to 40 feet above mean sea level. And that's specifically written in their codes. So that is also listed there on in your chart. So there are additional regulations that limit the overall height in FEMA zones in the South Fork. And I'm not going to go over all of them with you now, but I've listed them. There are other tools that you have already looked at and imposed in other places of the village, such as pyramid regulations. Most of the other towns have pyramid regulations that are still being applied in these FEMA zones from natural grade. So there's kind of a combination of regulations that are then affecting the heights. You do have pyramid regulations, but generally not in the zones where you would have the FEMA that's in the R 7.5, 12.5, and R 20. There's other factors like the limitation on the number of stories that are habitable. Other municipalities have sliding scales for heights based on the lot area. And then there are other pitch of roof considerations. So a lot of these are all described here in the letter. And in closing, the Southampton Association commends you for commissioning this study and having the moratorium for new and pending applications. And I just, of course, as you would imagine, we see record sales, record prices for home sales in the village of East Hampton, in the town of East Hampton, all of these other municipalities in the village of Sagaponack, mostly waterfront homes. You're in good company in terms of how you may or may not be affecting property values. We're kind of all in this boat together. There was a question, and I don't know, it may be something that you would also want to, or you may even know what the answer is, but how does this affect the fire department's ability for putting out fires as the homes get higher and higher, and where would they be putting the ladders, and how how is that going to be taken care of? So again,
With every application, the fire department looks at, John, am I correct? The fire department looks at the firefighting approach that they have access to and from the property. So it is something that plays a role with the fire marshal as he investigates each one of the applications.
terrific. So if a building is going up 54 feet, and based on what the elevation is, if you were starting at 4 or something, we're getting to some pretty tall ladders.
Yeah, but we are, our training is around the hospital.
Yeah.
And the height of the hospital. So our guys have ladder trucks. They do the training. They have the all the equipment to be able to attack fires of substantial height.
Okay. And you may also want to look at other areas that might need to be sprinkled. I know that the third stories are, but maybe other things too. But take a look at all of the concerns.
Okay.
Thank you.
One question for you. You have the when I was looking at the Village of East Hampton on a maximum height here, and you said it goes to 36 on increases per lot area up to 36 feet.
Yeah.
I thought it read 40 feet in their code.
The maximum height?
Maximum height in the Village of East Hampton on the larger lots, and I want to say 3 acres plus, if I'm not mistaken, goes up to 40 feet. I was just curious.
Not to my reading of it, but...
That's when April, back when Bruce came in, I did some research, pulled out the different municipalities, and I know that they start like at, I want to say 27 feet, I think, with the smaller zones, and then step up. It's not zones, it's by lot area.
It's clearly by lot area.
And I, if I'm not mistaken, I think their code set up to 40 feet on the larger lot area, which, so I didn't know how new the information was here.
Okay, they also have fairly recently revised their code in terms of pitch. So kind of with a steeper pitch, you could go higher. So I will go back and look and see that I've given you the most updated information.
Okay.
As we know, municipalities are changing their codes to deal with this.
Well, it's a challenge for all of us, so, okay.
Yes.
All right, thanks.
I'm sorry? Do you need the slide? No, that's for your record.
JDC.
Good evening. I'd like to thank the board also for this opportunity to discuss this so fully. My name is Jay Deasing, and I'm president of the Southampton Association and also a village resident at 109 Old Town Crossing. I think with all of the speakers, we have lost a little bit of sight of the reason we're here, and that's because a code is meant to set the rules and to make sure that everybody understands them and plays by the same rules. And our code pretty clearly states that 35 feet plus 2 freeboard above the current grade is the maximum height of a home. And as Rick mentioned, we have practiced something different, but it wasn't a law. And in fact, no change to the code was ever made by any act of this board or by any public process. And so I commend you on now recognizing that with the change in the flood laws and the heights. And we've been speaking with you, I believe, since really late last year. And Bruce did a wonderful job in April of presenting the problem and bringing it to the forefront. But this really isn't anything that new. We've recognized there's a problem, and that's why we're here. And that's why the Southampton Association had Myers, Swazi, English, and Klein prepare a document, which I believe you all have copies of, which says that you can and should approve this moratorium as written. There are certainly many differing objectives and interests here in the room tonight. But I think the greater good of the village is to maintain the charm of our historic beauty, of our beautiful oceanfront areas. And I think it's really critical that you take this opportunity to, for 6 months, have a moratorium. There's an out clause if it's needed, and put a law together that actually accomplishes what we need, which is to make sure that both new construction and existing homeowners are respected. So I would ask the board to close the hearing this evening, and at the earliest opportunity, when they've received notice back from Suffolk County, to vote and approve the moratorium. So I thank you for your time.
Okay, that's everybody who signed up. There were some other people that you wanted to speak. Yeah.
I just found out about it two hours ago.
Actually, just since anybody else who comes up here, if you'll just state your name and address for the record, and that way we have it.
I'm Helge Herford from 547 Meadow Lane. I just found out about this change 2 hours ago when my contractor was there. I got flooded 3 times in 5 years. I had 2 feet of water in my living room during Sandy, and I'm raising my house. And I'm supposed to do it in 6 weeks, and the FEMA is asking me to raise it 8 feet, which would bring it above that height, obviously. And you bringing me down. I have no idea what to do. Just wait and see for the next storm. For the ocean is rising, we know it. It's going to be Sandy was 2 feet in my whole house, and it's going to be 2.5 feet the next Sandy. I can't believe what you're doing. I mean, you have to make an exception. It took me 4 years to get these damn permits. It took me damn 4 years. The only permit I need is from the village, and now I'm here? I can't believe it. What do you want me to do?
Well, that's why in the moratorium there's a...
A moratorium takes 6 months.
No. That's why in the moratorium, during that 6-month period.
What?
During the 6-month period, there's an opportunity for you to put an application into the village board to allow you to do that.
In the meantime, I am close to the border, and I have no choice than raising my house. I don't even want to go up 8 feet. I wish I could go up 6 feet, but they make me 8 feet. Why don't you make an exception? I can't believe you. Putting me under this hardship now?
I don't think there's an opportunity for you to put in front of the village board to raise the height of your house. There's a formula. There's a procedure there for you.
Where do I go?
You would go right here to this village board and submit a letter and request.
What would happen after? What would the result be?
What's that?
What would the result be?
I can't speak for the village board here.
I would rather not raise my house, believe me. I'm 69 years of age. I don't want to raise my house. It's the last thing I want to do. And here I'm forced into it, thanks to global warming. In 4 years getting the damn permit, fighting for it. I can't believe it. If there is a chance that I might succeed and raise my house in 6
You know
weeks?
exactly where your house is.
I know you do. My cat got almost killed in front of my house because of high-speeding Porsches in front of my house on Meadow Lane, yes. Is there a chance that somebody makes an exception on me?
There's always that chance, yes.
Where do I go again?
You would go to
When
the
shall I
village.
come back and do something?
It's as soon as you can.
When? Tomorrow.
Well, I mean,
Where do I go?
you would submit a letter to this. Actually, why don't you meet with the building inspector?
Mr. Foster.
And yeah, okay.
We haven't adopted the local law yet. An application for an exemption could not be made until after we adopt it.
I'd just like to say I met with Mrs. Herford a number of times, and her house is historic. It's a Normandy-style house, and a bunch of us are aware. She does have a water line inside her house, and it really needs help, and I think it probably would. I can't answer where you go, but it would qualify for leniency.
Thank you. Mark?
Mark Matthews. I'm an architect in Southampton for 35 years. I think that there's just a couple of issues that should be emphasized. First off, not many people know, but the FEMA elevations didn't just go up. They also went down in some areas. So just for the record, it's just true. And the second point is, and I work in all the towns and know all the rules, but I would also say that the board should be very aware of what having a restrictive elevation is going to do to the architecture in this village. It really should be looked at very carefully, because this village typically is this, and it will prevent that. And number two, I think before any real decision is made, I think there ought to be a very clear understanding of how many properties are affected, and see if it's a big issue or not issue. I think it is, but I think it's easy to figure it out, and that there's plenty of county maps that have all the topos on them, so you can see what the existing grade is and look at the FEMA things. So there should be a little study done on that very fast, so that you know what you're doing to home. Thank you.
Thanks, Mark. Thank you. Anyone else from the public would like to speak? Okay, so we're going to hold this open.
Yes, I would suggest that you make a motion to schedule a special meeting of the Board of Trustees to be held on September 4, 2014 at 6:30 p.m. and to adjourn the public hearing to that special meeting.
If I may be heard on that?
Wait 1 second.
Okay.
I'll make that motion.
May I be heard on the motion for us?
Yeah, 1 second. Let's just make the motion so we can have a discussion around that. I'll make the motion. Will we have a second on that?
Second.
Second. Discussion from the board. Comment from the public.
This is the second time you've held a special meeting, and it's very obvious why you're scheduling a special meeting on September 4th, because the Architectural Review Board meeting is on September 8th, and your regularly scheduled meeting is on September 11th. So you're clearly targeting certain applications, which is simply more proof of your unalloyed political motivation on doing this. You have had two special meetings on this. I would suggest, what are you talking about? What's the difference between 4 days? What's the difference between the 4th and the 11th? Excuse me. 7 days? It's 7 days of an emergency? It's not that. You're clearly trying to have a special meeting prior to the next Architectural Review Board meeting. Your political motivations are being hung out to dry, so obviously. So I would suggest that you do the fair and right thing and simply take this matter up at your next regularly scheduled meeting. My fear is, since the political motivation seems to be the overriding thing, that it's going to fall on deaf ears, but it's obvious what's going on here. You have 7 days until your regularly scheduled meeting.
So we've opened it up for public. Susan, come on up.
I have to step outside for 2 minutes. I'll call Susan. Susan, excuse me I must call someone.
Okay.
Oh, okay.
Go ahead. No, you come on.
Hi, Susan Stevenson, 84 Toilsome Lane. Because there are requirements that the Suffolk County Planning Commission has to review or pass on the law creating the moratorium, and I believe that the reason for the scheduling of the meeting is that board meets on that day at 2 o'clock, and therefore you would have at least no obstruction from your requirements by the county to approve or disapprove of the moratorium. On a personal level, I live in the village, I'm a resident. I really care about how it looks. I'm very concerned about what might be happening. I do not believe that the paranoid political version of this is necessary. I think that there are many people in the community who are asking you to take a good look at the zoning and to help us preserve the community and the way it looks. Thank you.
Yeah, Evan, go ahead. Come on up.
I'd like to second what Susan just said. We should be looking at the entire zoning, not just one little strip. The problem exists throughout the village, the problem of how the zoning law is applied. And to make the moratorium on that narrow proposal is not fair. We should be looking at the entirety of the village and your whole zoning code. Thank you.
Anyone else have comments? Okay. Okay, so we have a motion.
Just for the
discussion.
record, this is adjourning the public hearing
Yes.
rather than closing the public hearing. There's nothing to say that the board will or will not, or will or we even be able to act on September 4. It's simply scheduling a final public hearing that we can then have and close and take it from there. There's nothing that says that the board will be able to act on September 4th. There's nothing that says that the board will vote on September 4th, even if you're able to. We have September 11 is a regular meeting of the Board of Trustees, normally a large agenda. We've had a lengthy public hearing tonight. Another public hearing will give the public more opportunity to speak, and that's what we're doing. So it will not interfere with the regular agenda on September 11th.
Okay. So we have a motion and a second on the table. Any further discussion from the board? All those in favor?
Aye.
All right, so,
Before I forget, Eileen, you should put a notice on, update the calendar on the village website to include that special meeting. Also a notice on the bulletin board, and also notify the media.
And also
we'll take a
notify.
couple-minute break here and stretch our legs. The break here, we have communications to the board. We have Joanne R. Douglas, Pelham Street.
Want me to read it?
I'll read it. If you
I
want
can
to.
read it.
Okay, go ahead.
Dear Mayor Epley and ladies and gentlemen of the board, I have been coming to Southampton for most of my life, as I have my entire extended family back to my grandparents. My dream was to own a home in Southampton Village. I always claimed it is my favorite because it was not a pass-through village. It felt safe, peaceful, and secluded. As I am closer to completing my home on Pelham Street, sadly, I am discovering that not only Pelham, but also most of Southampton Village has become the shortcut or speedway for commercial and commuting traffic to either other towns, the beaches, or the campground. We are all entitled to the quiet enjoyment of our home and community. Has this come to an end, as well as diminishing property values? The busier a neighborhood street becomes, the less your house will be worth. Plus, I don't think any of us, whether we live, summer, or work here, want the road noise, traffic density, increasing road rage, and increasing danger. Accidents and personal injuries are rising. I have put away my bicycle till after the summer, and I have seen other neighbors put up signs saying, "Drive like your kids live here." A very scary and exponentially mounting situation as building and tourism grows. It is apparent that many commuters, trade traffic, trucks, and fancy cars as well, have found that they could drive faster cutting off 39, speeding through our village streets till Cobb or vice versa, and then scooting back on. Here is a partial list of what I find are the worst streets: Moses, Pelham, Prospect, Henry, Corrigan, McGee, North Main, Elm, Powell, Herrick, Halsey Neck, Gin, Meadow, Bishop, Little Plains, Old Town Road, Wickapog. I've seen traffic back up on side streets, fast cars dangerously pass slower cars, and even driving up on the grassways, or speed off at the next intersection to get around the slower traffic, not to mention tailgating. Villages in other states have addressed these issues in various ways, not just to save property values, but mostly to save a peaceful way of life and their lives, including their children's. Okay, Here are my thoughts and suggestions to encourage those just passing through to stay on the county roads and for all of us to stop speeding. 1, change the speed limit on all village streets to 15 miles per hour. In some communities, it is 5. Coordinate with the county to change the traffic light sequences on 39 to allow that traffic to move faster. Number 3, have traffic police issue tickets for 16 miles an hour and up. Word will get around fast. By the way, Pelham and North Prospect have become drag strips. Number 4, immediately start ticketing trucks that use side streets without a local destination. 5, curb the construction and party setup vehicles, and if there are more than a certain number, have those involved employ traffic police through permitting. These are relatively easy, not costly, and will add revenue through the ticketing and permitting. The rest would take more time and money, but could be the best thing we do with our community. Number 6, narrow the roads, add more shoulder for emergency vehicles. Narrower streets naturally allows for slower driving. Number 7, add more bicycle lanes with road bumps along the lanes as another means of narrowing the streets and still having emergency vehicle access. Number 8, as streets are repaved, use more tar and less gravel. This reduces street noise by about 65%. 9, put up staggered freestanding fences, barricades in the streets that force cars to go around, changing their speed and pattern and alternating with oncoming traffic, especially during the busiest season. Very effective in Connecticut. 10, install radar cameras for automatic ticketing. 11, while our police and crossing guards have been doing an excellent job in town, add motorcycle police for additional traffic control. Here is what I am willing to do before next summer. Set up a blog, send out a mailing, hand out flyers, and advertise in our local papers to encourage everyone to be aware, to call the police when there are dangerous situations, and to take the pledge to drive 10 miles an hour. I will make bumper stickers available that say, "Save Southampton Village, drive 10 miles per hour." Sincerely, Joanne R. Douglas. I think that's it. That's it.
The other letter that we have
The
is
other letter.
in reference to the public hearing.
Right.
So,
Did you want me to read that?
I mean, we did read the other letters into the record and allowed everybody to speak, so I can read this if you want me to.
Oh, my.
Go ahead.
From Frederick Snyder and Leslie Snyder. Dear board members, we are the owners of property located at 1400 Meadow Lane in Southampton Village, having owned it for about 44 years, and understand that you are in the process of considering the adoption of moratorium which would prohibit development or redevelopment of certain buildings and structures currently existing which would exceed 35 feet in height measured from natural grade in the case of a pitched roof house, or 27 feet from existing grade for a flat roof house. We have a lawfully existing house on our property, which we believe may exceed these specified height limitations, and wish to express our concerns about adoption of the moratorium as we understand it to be structured. We have been considering, among other things, making some alterations to our existing residence, while not necessarily increasing the footprint of our house, nor making it any higher, but doing certain renovations and alterations on it. We understand that such activity would be subject to the moratorium, even though we would not be making the house any taller than it currently exists. Since our house has an existing height condition, which is currently legal under local zoning regulations, we cannot really understand the policy reason which would prevent us from making alterations to that existing structure without increasing its height or even making any additions which would equal the same height. We would thus ask you to consider whether or not the moratorium should be limited to new construction only and not to existing structures. Also, our existing house is in the flood zone X, which we understand is not a flood zone, and partly in flood zone elevation AE9. Our house is also located south of the coastal erosion hazard line, having been constructed before the coastal erosion hazard area regulations were in existence. One thought we had considered and would still like to be able to consider would be the relocation of our residents further down landward, possibly to exchange its location for the location of our existing swimming pool, which is located northward of the coastal erosion hazard line. If we were to do this, it would appear to place our entire residence in flood zone AE9, which would require a first floor elevation of 11 feet above mean sea level, the FEMA elevation plus 2 feet of freeboard, which New York State requires. Under the moratorium, since the height of the structure would need to be measured from natural existing grade and not from the FEMA elevation plus 2 feet, as has historically been the case in the village, this would severely and significantly limit the scope of new construction, which would arguably be beneficial because it would be located landward of the coastal erosion hazard area line, which we understand is a desired result. In other words, this moratorium legislation would have a chilling effect on making things environmentally better. We are sure that there are other cases in the village where this situation would apply, and the environmental effects of such restrictions would, in our opinion, be detrimental. As a result, we would ask you not to adopt the moratorium legislation as it is presently drafted, and reconsider modifying any moratorium legislation to take into account existing buildings and structures, and also situations where the moratorium restrictions would have a chilling effect on new or altered construction, which would be conforming or more conforming to environmental regulations, such as the coastal erosion hazard area regulations. Please make this letter a part of the record in connection with your consideration of the proposed moratorium legislation. Thank you.
All right, no further communications here. We got suggested resolutions.
Number one, resolve that the reading of the minutes for the public session of August 14th, 2014 be dispensed with, and that those minutes be accepted as filed by the village administrator, and that the actions taken at that meeting be and hereby are ratified and approved. Can I have a motion?
Make that motion.
And a second?
Second.
Any discussion? All in favor?
Aye.
I need to abstain. I wasn't present at that meeting.
Thanks. Number two, resolved that the claims for the warrants dated August 26, 2014, totaling $107,781.54, warrant number 5, the general fund, $1,819.33, warrant number 4, CS trust fund expenses, $258.21, and warrant number 5, trust fund, and the village payroll through August 21st, 2014 be audited and approved.
Make that motion.
And a second?
Second.
All in favor?
Aye.
We need discussion on it, and let's go through and,
Oh,
did
okay.
Steve, you list you what each one of them
Oh,
are
yes,
for?
I
Okay.
did that. So anything over 1,000.
Anything over 1,000, so it should,
Okay,
Go
so,
ahead.
Or is it usually
Um,
highlighted?
yeah.
Is hers highlighted?
you want me to just start?
Just
Okay,
where
so
it's highlighted at, yeah.
Right, so 71 Hill Street is the September rent.
Yep.
Aldo Andreoli is the June payment.
We just normally just read the amount too, so
Oh,
that way.
I'm sorry.
That way the public can hear it too.
Okay.
So, yeah.
So the 71 Hill Street, $4,774 is the September rent. Aldo Andreoli is the June payment, $1,250. Don Bennett, $1,000 medical reimbursement. CSEA employee benefit, $23,391.90. It's the September premium. $1,000 for Corwith Christopher, medical reimbursement. Devitt Spellman Barrett, LLP, $2,076.66. That was for Conrad versus the Village. SA Plumbing and Heating, $1,695. That's to supply and install the RPZ valve at the Chamber of Commerce. Firematic Supply, $1,350. That's for 10 5-gallon pails of Ansulite, 3%. And Firematic Supply for $1,831.92. for parts for the hook and ladder. High-tech fire and safety, $1,270.86. That's for 6 flip-down shields. Mayday Communications, $6,366 for 6 radios. Mayday Communications, $1,548. That's for a mobile radio and a mic. Mayday Communications, $3,500. Annual service maintenance, 24-hour audio log, voice recording. Moore Medical Corporation, $1,443.05. It's miscellaneous ALS supplies. Rapid Recovery Towing Service, $4,150. It's for police towing fees. Red the Uniform Tailor, $3,948.50. New uniforms for the police department. RS Sales, $1,331.88. That's just miscellaneous supplies, hand sanitizers, etc. Strata Baxter Design Build, LLC, $6,267.33. That was the deconstruction on Pond Lane. Suffolk County Vocational Ed and Extension Board, $1,000. That was for manuals for the fire department. Sunbelt Inflatable Tents, $2,997.50. That was for a sealed rehab tent. That is the balance due. Vincent Toomey, $4,986.
What's the sealed rehab tent? Do you know?
The sealed rehab tent, let's see, 4540 account is the ambulance. So evidently we bought that a while ago, and that's the balance due on it.
And they support the fire.
Yeah.
Fire calls.
So if somebody's injured, they can take them into an isolated area.
So that's the remaining balance on what's
Right,
due.
okay. Yeah.
So they
All right, I
made
just
a
didn't know
payment
what it
plan,
was.
I think. Vincent Toomey for $4,986.94. July expenditures. Upbeat Inc., $1,074. That's for a picnic table for the chamber. Vertex Water Features, $1,577.24. That's a compressor kit, a replacement for Lake Agawam. And for the warrant for,
Yep.
yeah, James Rambo, $1,600. This is the mooring and the ramp for the ferry, Lake Agawam.
Yeah.
And that's it.
We have a motion and a second on that. We have further discussion. All those in favor?
All in favor?
Aye. Okay.
Number 3, resolve that the Board of Trustees hereby approves the hiring of Nicholas Bontempo as a chairs and umbrellas attendant at Cooper's Beach at an hourly rate of $9.
Make that motion.
And a second?
Second.
Any discussion? All in favor?
Aye.
Number 4, resolve the Board of Trustees hereby approves the hiring of Joshua Hostetter as a dockhand at the Lake Agawam Ferry at an hourly rate of $10. And I have a motion.
Make the motion.
And a second?
Second.
Discussion? All in favor?
Aye.
And resolved that the Board of Trustees hereby approves the hiring of Johanna Moore as a beach attendant at Cooper's Beach at an hourly rate of $9. And a motion?
Motion.
Second?
Second.
Discussion? All in favor?
Aye. You get through the resolutions there, okay? So you didn't stumble around too much?
Not too bad.
All right, okay.
Not too rusty.
Okay, good.
Thanks. The discussion items?
And we have an application for a Southampton High School Student Council. I'd like to, I think that's the back of school at Cooper's Beach on 9/15. And we've done this in a couple of years. I think this is a great place to do this. And so I'd like to make a motion to authorize the Southampton High School Student Council to back-to-school night at Cooper's Beach in accordance with their application.
And a second?
Second?
Any discussion? All in favor?
Aye.
Okay. And
Yeah,
next
but-
discussion item, syntax. Is
We
the
have,
letter?
one of the things, so for the new ambulance building, is a public information that needs to be, a campaign for, we did this with the firehouse. It was very helpful for the public. And we engaged Syntax, and Michael Conti's done a lot of stuff around. He did the library, he did the schools, he's done the fire department, and the ambulance has asked that we do a whole public relations piece around there. I strongly support that. Rich, did you have anything else you wanted to add to it?
No, just that, it's good for, to do the PR like we've done every other building.
It gives people an opportunity to have a well-informed, educated vote. So I'd like to make a motion that we hire Syntax in accordance with their proposal for communications for an information campaign for the proposed ambulance building dated August 20th, 2014. The fee for their cost is $5,000. We need a second on that?
Second.
Second that.
Any more discussion?
Discussion. All those in favor? Aye?
Aye.
Okay.
Third is the sewer district. There's a letter in there.
The Planning Commission, over the last couple of months, has put the RFP out, and they have, interviewed, they studied the RFPs, they interviewed a bunch of firms, and they've come back with recommendations that we engage these firms to begin the sewer district process. And I'd ask for copies of these things. Do we have copies of their proposals? I know it's not in here.
Yeah, I didn't get anything. This is the only thing that I had an attachment of.
Okay.
So I put this in and then,
Okay. I don't know if it is or not. So, let me run to my computer and check out, and I think he sent an email. So if you give me 1 second. Okay.
Did you find it? No?
This is the only attachment on here. So, because what the Planning Commission's done is recommended that we engage H2M and Cameron Engineering, do the engineering services, and the law firm of Farrell Fritz to engage in legal services to prepare and file the map and plan required for the creation of the sewer district. Rick, I want to engage these guys, but I don't have an engagement letter from them or the cost of it at this point in time. So,
Okay, is it urgent that we do it now?
no, I think we can do it at the
We are having a
special
special
meeting.
meeting next Thursday.
So,
put
let's
it on
do,
special.
because actually, that'll be right after the Planning Commission, and it'll be a topic of discussion at the Planning Commission. And I think it's important that we put the monies aside to budget for this, and it's very important for the future. So, okay.
motion to postpone it to the September 4th.
Well, it's just a discussion item, so we don't have to do any
Oh,
motions or
okay.
anything like that.
Okay.
So, but I don't know how many people had an opportunity to see the interviews and stuff, but just to, just to give you a background, it's H2M and Cameron Engineering. Cameron, H2M partnered with Cameron for a couple of reasons. One is that Cameron started working with the village years ago. They do the hospital system, and when Mayor Romanowski and the board had requested a proposal, they did a study for a vacuum system in the village business district. And then H2M has been the lead agency for the county of Suffolk to study sewering and make recommendations and studied quite a few areas, and the village of Southampton was one of the big areas that they spent time with. And H2M also was the firm that did all of the village of Patchogue sewers, and has worked with them forever. And as Mayor Pontieri had called me up and said that they designed a system, managed the project, and brought it in on time, under budget, which was and you know, he's worked with them for many years. And and then Farrell Fritz, and that is Chris Kent as one of the lead counsel, and Eric Bregman. And Chris Kent was a deputy county exec at one point in time. He led Suffolk County and studying septic, and was the town attorney for the town of Riverhead, highly involved in their sewering districts and maintenance of it. And then Eric Bregman it was the town of East Hampton's lawyer with Farrell Fritz, and has done a lot of municipal work also. And so I think they're really two great firms that we've been privileged of putting the RFPs in, and will bring a lot to the table for us. And I think that it's the right thing to do. We had some great applications that came through, some very interesting people and projects, and I think the Planning Commission chose wisely on this. So,
H2M had done a lot of background, research in the village.
Yes.
And Cameron is, they already did a study, so
right.
It's a natural fit.
It is a natural fit, so it really is. So allows us to take that next step. So when we have those actual proposals in front of us, we will those motions and get moving on that. So that's it for the discussion items associated with this. So we got comments from board members. Trustee Ostrowski.
Just as nice to see everybody show up tonight for a very lively discussion. Again, I always like to see a packed room. So again, I thank everybody for showing up and expressing their concerns and questions. Other than that, everybody have a safe and happy Labor Day weekend coming up.
Mike.
On a sort of a different note, I was really interested by Joanne Douglas's letter, because the traffic this summer has been really, really tough, especially on the small local streets. And I really thank everybody for putting up with it, because it can be pretty frustrating at times. And it's not that this board, I don't think, has ignored the issue. I think this year we had more building going on in the smaller areas and the smaller lots in the village, and that causes a lot of street crowding and a lot of difficulty on traffic. So, I thank everybody for putting up and behaving correctly, and I think we did pretty well. And be safe for this coming weekend, and hopefully we'll have a great fall and good weather.
Great. Thanks, Mark. Nancy?
I'd like to comment on Joanne Douglas's letter as well. The roads that Joanne Douglas points out are all of the roads that I have great concern if King Cullen goes into Tuckahoe. I've pointed this out to the town board. These are all of the streets. And if Joanne Douglas is now saying that it's been bad this summer, when people are cutting off County Road 39, shopping in King Cullen, and then traveling all those back roads, because they won't get back on that highway once they get off it. I'm telling you right now, if that application, which I have been told is very close to being approved, and he's going to move forward with that King Cullen, people had better step up and say something about it, because I'm very upset over it. And I've told you, and I've told the rest of the board, I really want to sue the town if they go forward with that application. It's wrong. It's wrong for our community. It is going to affect every single one of our little side streets where the houses are 30 or 35 feet from the road. They have no business in allowing this, especially since our rules and regulations along that highway do not allow for it, and I'm very upset over it. That's what I want to say.
It's funny you said that because as we were reading that and I'm looking at the roads, I'm thinking exactly between that. I think part of the issue also is that the new light down at the St. Andrew's Firehouse
Correct.
has created a backup all the way into the village.
So now they're
That's done a lot more.
They're going to
So-
figure out ways
so
to get
now
around that.
what's
yeah.
happened is that these roads that she's identified now are getting the brunt of the traffic of people kicking off of Hill Street.
Yeah, that's where a
and
lot of it is really.
Halsey and Breeze
It's
and
like when you have the
Moses.
accidents,
And now if you go to County Road 39 at the red light at Sunoco, which historically is always backed up in the morning, especially during school, people trying to get the Tuckahoe, and it backs up people trying to get onto Sandy Hollow. Now it's backing up on North McGee Street, and it backs up all the way up to where it splits with Moses and stuff, or further, which is something historically has never happened, but because of the light now, we've had that increase right now, and it happens for a period of time. So try to get gas at Sunoco, and then pull out and head into the village there. It's a very difficult and challenging piece. So.
Well, also, I mean, they will have an entry and an exit off of that street, McGee Street. So you know and I know, people who are traveling into Southampton will go in there, people who are traveling to Watermill will go in there, people who are traveling to East Hampton will go in there, and then they'll mosey on right through our little side streets to cut down exactly what she's saying here, to get further east in any which way that they can. It's wrong. It's
White
absolutely-
Street has gotten to be pretty heavy too.
Right.
They use that as a cutoff.
It'll have an adverse effect on our community, and I think it's wrong. And I've said it from day one.
I know you have. So it's.
But that light up at St. Andrews is a biggie, and I even know that, at the
Well, we sit in.
town, and we all send stuff up to the
Yeah,
to the state saying.
Since
What was
a
the
lot of.
urgency all of a sudden of you installing a light? And I guess he demanded some type of documentation or studies proving the validity of the
Yeah.
necessity of that light. I think we're all waiting to see that.
Yeah, that's what we're waiting for. So it's between King Cullen and that light. You're right, and it's a.
I mean, there isn't even a longer enough length on that highway to have a turning lane there.
Right.
To go into that King Cullen.
No, it's not.
There's just not enough of
It's
a
not.
length. So I don't know how they could even say that they could have it there.
Yeah, there's
There's very few turning lanes on 39.
I know.
Come on.
Yeah.
And I don't want to be on one of them.
Yeah. No,
It's dangerous.
It does.
Yeah.
It's a very dangerous.
That's an interesting
situation,
road.
So, yeah. But I would like to. My comments are, the Southampton Arts Center, I think has done a fantastic job this summer. Last year, from the beginning through October, there was about 10,000 people had gone in and out of the building and participated in the activities. So the number right now is the middle of August. It's over 15,000 people have participated at the Southampton Arts Center in about a 7-week period. And we got Jaws coming up on Friday night. Thursday night's outside. Thursday night is that summer fest with the different restaurants that are participating, and it's going to be it's been a good summer there, and I thank those people. I mean, the Cultural Center's done a fantastic job. The concerts in the park have, other than the one rain out we had, which was going to be New Life Crisis down on the beach, which would have been a great time. It's got great turnout and they've done a fantastic job, and with all the different programming and the arts events, and so we have we have successfully disassembled 51 Pond Lane, and in the process of I think Robert Strada has done a great job and worked with the property owners, and now it's the goal here is to establish a location and fundraise to rebuild the structure and put the acknowledgments up on the property. And then also the ferry, the Pierce Concert Ferry that has been traveling, started a couple of weeks ago on Saturdays and Sundays. And I think, Brenda, we were able to coordinate that for the ribbon cutting tomorrow at 5 or not? Not yet. We're still waiting on everybody.
I sent the email out.
Okay.
They said it's gonna happen. I thought,
Okay. Okay, so
ribbon cutting.
we're trying to do a ribbon cutting for the ferry itself at 5 o'clock tomorrow. So if you're around and you're available to show up, it would be great. And I think they've got a lot of very positive feedback. And Brenda took it out, rode out with them and stuff. It's a beautiful ride.
Selling out of tickets.
Selling out of
I had
tickets.
to order more
Wow.
tickets yesterday.
That's been great.
And then
so.
they divided the an adult fair and a children's fair.
Okay.
So, but we got
great.
that ordered.
So I think it's done very well, and they've stayed in the middle of the lake. I think they're respecting the privacy issues of all the property owners around there, and I hope that it's not had any kind of negative impact on the people on the lake. But I know from a historical standpoint, what's that?
No phone calls.
No phone calls. That's good.
That's a positive thing.
That's a positive thing. Yes.
Start?
Until they see this, and then they start calling. Right now, but so it's.
Survived the Kardashians.
No, the Kardashians have left town.
Yes, they
And they were not anything. I had the privilege of meeting them, and my daughter got to meet them. What's that?
You're the one who met him.
And
Village Hall.
it was a non-event, and I think it was I think there were a lot of people that came to the village of Southampton to go to
It
Dash
was a boost to business.
and be able to see the Kardashians, and I do think they were a boost to the business out here, and it was, and so I think the property owners were happy with the business it brought in there, so it's good. And it was really, as I hoped, a very non-event around here.
Very responsive to the
and their team worked well. I think in other communities further up the island, there were mobs of people trying to see them and stuff, and around here they just were treated like everybody else who comes out here. So I think it was a good non-event, and hopefully the village of Southampton's portrayed well on the show.
I don't know about you, but
So I don't know about me, but that's okay. That's okay. So won't be the first time. Won't be,
Rowan, what was it, the medical show.
Well, growing
Pains.
Growing pains.
Fine,
Yeah,
too.
growing pains.
They
There
wanna
we
come
go.
back out
A
here.
celebrity.
I tell you, as my kids say, I'm a Z-lister. So.
I get you in the movies.
Yeah, there, she get an actor's license.
Get a card in there.
Like, well, you
It's
want a
about
film
as-
permit, you have to put the mayor on.
Yeah, that's right. Channel 22 is about as far as I really worry about, so it's all good. But so that's so it's been a good eventful summer, and I hope this moratorium process works out, and so we'll see. It was a good evening for debate, it really was. So proud of the way everybody. Yep. What's that? Oh, the sandcastle contest
Yes.
at Cooper's Beach on Saturday.
Saturday at 2 o'clock.
2 o'clock. Okay. That's when it begins, or are we judging there?
You start judging at 2.
Start judging at 2 o'clock.
Kate called, are you and Rich able to go down for judging?
Yeah, we'll go down.
Okay, good.
We'll go down. It'll be fun,
Okay.
as always. So, and then, but it's good. So we had some great
Is that on what,
projects in front of us.
Saturday.
Oh, Saturday.
So we've got some great projects, the
Sunday's weather
ambulance
is-
barn, the sewer systems,
Good improvement there, things going
some
on.
good stuff, investments in our infrastructure that will have long-lasting impact, positive impact around here, so. Okay, so second public comment, anybody from the public would like to make a comment? Okay, so I'm going to make a motion to close the meeting since we don't have anything on it for executive session, okay?
And a
Joining
second?
and adding. Second.
Second.
All in favor?
Aye.
Aye.